Everyone, and a warm welcome to the salubrious surroundings of the Hodge abode. My name is Alastair Hodge.
And I'm Claire Palmer. And as you can see, we're working from our respective homes. This is certainly a first for me, giving a seminar to solicitors and others in my jeans, but there we go. This is the second from our Working from Home series of seminars, the Safer series, which, as some of you will know by now, is a series of informal talks given by members remotely of 5 Essex Court. We hope that this provides an informative but also a welcome break to your new routine as we all get used to the new normal of staying at home. Just to let you know that Barney's seminar on police powers last week is now available to download online, and that 5 Essex Court has today launched a new publication, Coronavirus, A Guide for Police Forces, also available for download. I'd just like to start by recording Chambers' thanks to George, who you've just met, our new head of marketing, who is responsible for putting this together, along with Aaron Moss. And George is your point of contact for anything to do with this series, including ideas for future events.
A few matters of housekeeping before we get underway. Firstly, for those of you who haven't used Zoom before, you will see at the bottom of your screen a chat box in which you can insert questions throughout the presentation. If you decide that you want to ask us a question, please preface it with the word question in capital letters so that we can pick out the wheat from the chaff. Obviously, in relation to a large number of areas, the questions may be somewhat speculative in their answers because the regulations are not yet in place. The presentation is essentially in 3 parts. Claire is going to be addressing firstly some fundamentals, discrimination, health and safety, and the right to be offered work. I'll then pick up the reins and speak to you about furloughing and some ancillary matters, and then we'll deal with a number of questions that we've had in advance of the presentation when we get to the end. So without further ado, it's over to Claire and her dining table.
Thank you very much, Alastair. So business, employment and our way of life has changed beyond recognition, but ultimately employment law remains the same, governed by the employment contract and also existing employment statutes and regulations, albeit in the context of the new coronavirus legislation. Redundancy is and remains a fair reason for dismissal, and there are of course obligations on both employers and employees under the contract. It can appear that there are mixed messages from the media and the government itself, which means that employees and employers may be wrong about what can or cannot be done. Ultimately, that is partly because there is no one size fits all. Some businesses are closing, others continuing and thriving, some people can work at home, and others simply can't. It's also important to acknowledge that people are scared for their friends, their families, for their jobs and for their businesses. Employers and employees should remember the need to communicate, be flexible and reasonable, and above all, exercise common sense. Of course, many of the issues that arise will be of employee relations rather than necessarily of legal requirements. The tribunal process is not quick at the best of the times, but with the current circumstances, getting access to justice will be a lengthy process. We're still awaiting guidance from the tribunals as to how hearings will work, and this is a topic we won't cover in today's seminar. So the key obligations that employers need to have regard to. First, the contract of employment, both expressed and implied terms. Secondly, health and safety, whether under legislation and also the common law duty. And third, discrimination. Under the Equality Act, there is a duty not to discriminate, but also the positive duty to make reasonable adjustments for disabled employees. There have, however, been some key legislative developments since the coronavirus outbreak. The Coronavirus Act 2020 itself, although that is of relatively limited impact on employment law. Those specific to employment law, broadening rights, relating to holidays, working time regulations, and statutory sick pay. But most importantly, the key regulations you'll need to have regard to are the Health Protection Coronavirus Regulations 2020. The first set came into force on the 21st of March 2020 and related to business closure. Those were replaced on the 26th of March from 1 p.m. with the Health Protection Coronavirus Restrictions Regulations 2020, which you'll all be pleased to hear I will refer to as the 2020 regulations for the rest of this talk. Those regulations need to be read in conjunction with guidance that is available on the gov.uk website. That's guidance provided by PHE, Public Health England, and the Department of Business. And it includes guidance to employers and employees, which was last updated on the 26th of March, as well as rules on social distancing. You'll have heard by now that the government has put many schemes into effect, from job retention to loans to schemes for the self-employed. Of course, they don't yet cover everybody, and I'm sure we'll see further developments. Ultimately though, while redundancy remains a fair reason for dismissal, there's likely to be an expectation on employers that they have availed themselves of these schemes before laying off staff, and otherwise dismissals are likely to be unfair. So, what are the obligations on businesses continuing to operate? What is essential? Who are key workers? And who has to go into work? For our amazing NHS medical staff, frontline police officers, delivery drivers, and those in the supply chain and many others, it is obvious they need to go to work, apart from where they're isolating or ill. But others have been expressly forbidden from operating. In summary, unless a business is one of those required to close, or where limitations have been placed on the way business is done by the government, then the current position is that employers can continue to conduct business, employers, and employees are expected to be at work unless that work can be done from home. Let's start by looking at the guidance. The guidance to employers says as follows: businesses and workplaces should encourage their employees to work at home wherever possible, that employees will need your support to adhere to the recommendation to stay at home, and that employees from defined vulnerable groups should be strongly advised and supported to stay at home and work from there if possible. Employees are told you should work from home unless it is impossible for you to do so. And it is recognised that sometimes that will not be possible, as not everyone can work from home. Certain jobs require people to travel to their place of work. If you operate machinery, work in construction or manufacturing, or are delivering frontline services. So where is this in the statutory framework? Well, it's the 2020 regulations. This sets out the extent of the restrictions and the need to have regard to them. Let's look at that. It's particularly regulations 4 to 7 and Schedule 1. Firstly, they impose restrictions on movement, Regulation 6. No one may leave the place where they are living without reasonable excuse. Relevantly, for these purposes, reasonable excuse includes 1. To travel for the purpose of work or to provide voluntary or charitable services where it is not reasonably possible for that person to work or to provide those services from the place where they are living. And 2, to fulfil a legal obligation, including attending court, or to participate in legal proceedings. Secondly, they prevent gatherings of 2 or more people in a public place. That's relevant. Exceptions is where the gathering is essential for work purposes or where it's reasonably necessary to participate in legal proceedings or fulfil a legal obligation. And then the list of requirements for business to close. This is dealt with in Schedule 1. Part 2 lists the businesses that must shut completely. Cinemas, gyms, beauty salons, car showrooms, auction houses. And many staff in those businesses will simply not be required. They're either at the risk of redundancy and more likely to be placed on furlough, although some may be able to continue doing their jobs from home. Part 1, the restaurants, cafes, bars and pubs, and the requirement there is to close parts of the premises where food and drink are sold for consumption on the premises. They can offer takeaway if it's online or telephone orders. Some staff will not be required, some will need to undertake different duties, and some will work from home. Premises that can stay open. Part 3 lists the premises that can stay open. It includes things like food retailers, pharmacies, newsagents, health services such as dentistry, podiatry, homeware shops. But otherwise, if you work in a business that offers goods for sale or hire in a shop, you must close except where making deliveries in respect of online, telephone or postal orders. It is not permitted to allow a person on the premises who is not themselves providing the service. And now we'll all be aware, won't we, from our own lives, that many businesses are being reactive and changing in the market and changing their operations to enable the business to remain open. In such circumstances, the business will be able to offer work to employees, and there is arguably an obligation, subject to terms of the contract, for employees to accept that. Where an employee is not willing to undertake alternative work, unless they're vulnerable, isolating or unwell, it's unlikely that there will be any right to continue to be paid. And if alternative work is offered, this is likely to be seen as reasonable conduct by the employer. Many of us will be asking the question, what is essential work? The answer is that there is no such concept. Contrary to some public opinion that no one should leave their house at all, the current legislation does not mirror that. Part 3 does not describe what is essential work, rather it provides who can continue to provide goods to the public in person. If your business is not covered in any of the above lists, but there's no direct contact with customers in person or in premises, then you can continue working. Some of the confusion has perhaps arisen because of the definition as to who can send their child to school, and the term key worker is sometimes used there. In fact, the Department of Education describes those individuals as critical workers. And if we look back at the guidance itself, the message is clear for the moment. With the exception of some non-essential shops and public venues, we are not asking any other businesses to close. Indeed, it is important for businesses to carry on. However, you should encourage your employees to work from home unless it is impossible for them to do so. So what are the requirements and obligations? First, there is an obligation on employers to offer work. The contract of employment that exists already sets the place of work, the job title, and summary of duties. If these can be continued, then the employer has an obligation to offer them. Place of work may not just be limited to the physical workplace. If it is, it seems to us that the legal basis to change that is the 2020 regulations to home working. If other terms need to be varied, first of all, does the contract allow the variation you're seeking? But ultimately, employers have an obligation, firstly, to take all steps to ensure that the employee can work from home, to provide items to facilitate that, be flexible in its business, and to relax certain requirements. Much of that has already been done, but we would suggest that employers need to keep under review and continue to reduce the workforce that are required to attend in person, or minimise the number of days and amount of time they need to do so. Secondly, employers should consider what other work could be done by the employee from home outside of the contract. It's plainly likely to be reasonable to vary duties to enable an individual to work from home, and good practice to provide alternative work in that period. Some contracts will already allow for that, but otherwise you can seek to agree with the employee to change in duties for the period, and again, the usual contractual variation points arise. Thirdly, we'd encourage employers to think creatively. What can be done? Request flexibility from your staff and think about who can undertake what. But don't forget the need to update terms and conditions if they're key, such as pay, place of work, etc., within 1 month in writing. Before sending staff home, make sure you get up-to-date contact details and permission to use their personal contact details if there's no email access at home. Secondly, employers have health and safety obligations. Such obligations arise under the Health and Safety at Work Act as amended, as well as the Common Law Duty of Care. Essentially, there's a requirement to conduct business as far as is reasonably practicable in a way which will ensure that persons are not exposed to risks to their health and safety. If workplaces are remaining open, employers will be well advised to consider those provisions as they apply to their business, update the health and safety policy, and provide clear and regular guidance to their staff. This is likely to include signage about hand washing and reminders and enforcement of the same, the provision of further cleaning materials, regular and increased cleaning of the workplace, and particularly of surfaces that are in regular contact, and to make sure that you send home anyone who becomes unwell with COVID-19 symptoms. It's also important to consider putting in place an appropriate feedback process where staff can raise their concerns and where employers can be reactive, and also give reassurance to those staff for being required to come into work. Employees who fail to cooperate with such rules and requests may commit disciplinary offences, And we would suggest it is important to give early warnings and to show that you're taking your responsibilities seriously. This again will give comfort to the employees. What other obligations are there on employees? Well, they have an obligation to do work. And of course, we recognise that difficulties arise where there are childcare commitments. Employees are likely to be able to take that as parental leave, but please remember there's no obligation for that to be paid unless that is already set out in the contract. It may be that the employer wishes to accommodate that by way of flexible working, allowing annual leave, reducing hours, placing the employee on furlough, or exercising its discretion to pay for a period. And of course, on employees, we'd say this does give rise to a good opportunity. Many of you have requested to work from home and had it denied. You've asked for there to be no in-person meetings and to do them remotely. If employees behave responsibly and make it work, there's likely to be a strong argument for amended working practices going forward and an increase in productivity in the business. Thirdly, for employers, the Equality Act legislation. Regulation 1 of the 2020 regulation defines a vulnerable person as someone over 70, pregnant, or with an underlying health condition, including but not limited to those set out in Schedule 1. That includes chronic respiratory diseases such as asthma, emphysema, chronic heart, kidney, liver diseases, or neurological conditions, diabetes, spleen problems, weakened immune systems from chemo or HIV, or also where people have a BMI over 40. The 2020 regulations do not actually set out any obligations on employers in respect of those vulnerable persons, but it will be relevant to the exceptions for health and safety and the reasonableness of decisions that are being made by employers. Where an employee falls into the above category, the expectation is that the employer should not require that person to attend work in person, but facilitate them working from home. Allow them to work from home before others. And of course, it's good employment practice to provide assistance to those individuals, even where there's not a disability. But where a disability arises, then of course there is a positive duty to make reasonable adjustments. This is likely to include the provision of auxiliary aids to allow working from home. Also, you may need to have particular consideration to those with visual or hearing impairments in respect of remote working and ensuring remote meetings have functions to enable those employees to participate. I next want to touch on the subject of mental health and well-being. This is incredibly important from both an employee relations point of view, but also because there's a risk to your business that your good staff, those remaining at work, will be off sick for reasons other than COVID-19. And it's going to be difficult to run a sickness absence procedure while they're away from the office, although of course that can be done remotely. People are facing a range of circumstances, including looking after children, having vulnerable parents, family or colleagues, as well as the general anxiety about the current situation. Remember that being there for your employees will reap long-term rewards and loyalty. So what should you do? Well, check in with staff with a call rather than just email every few days. Keep in touch generally. Arrange virtual social events for networking and for downtime. But also perhaps think about a guide on conduct. Remind people to say please and thank you in emails. Remind people that because they're not seeing people, they don't know what they're facing when the email arrives in their inbox, and just to be a little more understanding. Perhaps appoint wellbeing ambassadors within teams. And also, because employees want to be part of something, why not encourage suggestions and implement them where you can? But what about when an employee is concerned about their health and safety? They will be rightly concerned for their health and safety and that of their household or other co-workers. We know that the virus is highly contagious, and there is therefore a risk of catching the virus from co-workers or on the journey to work, particularly if public transport is the only option. So what rights do employees have? Well, the Employment Rights Act 1996, Section 44. That is the right that an employee must not be subjected to any detriment because he or she has raised a relevant health and safety concern. There are two key areas, what's described as evasive action and what's described as protective action. Evasive action is where in circumstances of danger, which the employee reasonably believed to be serious and imminent, and which he or she could not reasonably have been expected to avert, he or she left or proposed to leave, or while the danger persisted, refused to return to his or her place of work or any dangerous part of his place of work. And then the protective action is where an employee, in circumstances of danger, which the employee reasonably believed to be serious and imminent, he or she took or proposed to take appropriate steps to protect himself or herself or other persons from the danger. The most likely situation given rise to potential claims during the current crisis is where an employee leaves or refuses to return to his place of work because they reasonably and understandably think it poses a serious and imminent risk of danger to their health. The danger could be posed by risk of infection from a member of public or from a fellow employee, and obvious examples are those in hospitals and supermarkets. An employer who takes disciplinary action against an employee in these circumstances is likely to be committing an act be breaching this section as a consequence of that. Section 100 also provides protection where a person is dismissed having raised such a concern. It also applies to constructive dismissal. There are implied terms of the contract. Firstly, the employer will provide and monitor for their employees, so far as is reasonably practicable, a working environment which is reasonably suitable for performance by them of their contractual duties, the duty of trust and confidence, and the common law duty of care. If employees are asked to work in workplaces without adequate protection, whether that be PPE or failure to adhere to social distancing, it's clearly likely to amount to a breach of this implied term. It may lead to the employer resigning and claiming constructive dismissal. And finally, I just remind you that no qualifying period is required for a Section 100 claim. And of course, interim relief is also available in such claims. Whether an employment tribunal is open to hear that claim and how quickly is a matter for another day. Thank you.
Can I now turn to the issue of furloughing? It is amazing that the English language has developed in such a way over the last 12 months. In 2019, the buzzword was Brexit. In 2020, it is the concept of a furlough, how the language changes. I'm going to try and deal with as much as I possibly can in the time that I have available. We've heard the speeches from politicians. Some of us will have read the guidance that is available on the gov.uk website. And this is all very well, but as of the date of presentation of this broadcast, we still wait to see the text of the actual regulations themselves that will put this particular scheme into law and into action. I suppose the only advantage of that is it may well be that Claire and I will find ourselves doing a further presentation very shortly once we have that legislative text. So what therefore is proposed? Well, in essence, it is a job retention scheme. All employers in all sectors, that includes both profit-making organizations and those organizations not for profit, will be able to benefit from the scheme. And put simply, what is proposed is that HMRC will reimburse employers for the employment costs of furloughed employees. A furloughed employee is an employee that is essentially placed on leave of absence. What, therefore, are those employment costs? Well, it's an either-or. It's the lower of 80% of the usual monthly wage cost before tax in respect of an employee as at the 28th of February of 2020 and £2,500. Therefore, a higher earner, their earnings will be capped for the purposes of the scheme at £2,500. But in addition to that £2,500 or wherever the guillotine falls, the employer can pay national insurance contributions on top of the 80% or the £2,500, as well as any minimum auto-enrolment pension contributions that the employer may be making in respect of an employee. The guidance so far tells us that the monthly wage cost will exclude fees, commissions, and bonuses. Therefore, we only look as though we're looking at a monthly basic wage. One of the questions that was submitted in advance of the presentation came from Joe Mackey. Good afternoon, Joe. And Joe made reference to trunk payments. Now, trunk payments occur in various industries, a sort of tip or service charge. And Joe asked whether trunk payments were likely to be excluded from the operation of the scheme. Joe, I think at the moment, I would say yes, they are, purely on the basis that if fees, commissions, and bonuses are likely to be excluded, then trunk payments are as well. Can I now turn to the minimum length of the furloughing period? And this is important for employers. The minimum length, it is proposed, that an employee can be furloughed is a period of 3 weeks. Furloughing, and the question came in from someone in advance of the presentation about this, if furloughing is done for a period of less than 3 weeks, then it will be outside the scope of the scheme. It must be for that minimum 3-week period. In order to be eligible to take advantage of the scheme, what does the employer have to do? Well, in the first instance, the employer must contact each employee whom it is proposed to furlough and confirm that they are being considered for furloughing. And under the scheme, as we've discussed, the salary can be reduced to 80%. But of course, this reduction to 80% must be agreed with the employee under normal contractual law principles, as well as employment law. And therefore, the best practice would seem to be, subject to what is contained in the regulations, will be for the consent of the employee to be sought in writing. This can be done by way of a furloughing agreement. Indeed, one such agreement that I've already seen contained various provisions. It's signed by employer and employee, and that takes effect. In terms of employers selecting employees, do bear in mind something to which Claire made reference to a moment ago, and that is the provisions with the Equality Act. Any decision that an employer takes to furlough an employee must be done in compliance with the provisions of the Equality Act of 2010. Ergo, it must not be discriminatory in any way. In order to benefit from the scheme, an employee or the furloughed employee must have been on the payroll on the 28th of February of 2020. If they weren't, then there is no eligibility for the scheme. However, the guidance suggests that if an employee has been made redundant since the 28th of February 2020 and has since been rehired, then such an employee would be eligible for the scheme. Of course, it would be essential for that employee that was made redundant to have been on the payroll as at the 28th of February. And the guidance seems to suggest that this scheme is going to apply to any type of contract: full-time, part-time, agency, flexible, 0 hours, including those on maternity and paternity leave. One of the questions that came in advance asked us whether casual workers would be eligible for the scheme. I think Robert, who submitted that question, I think the answer is potentially. It will obviously depend on the terms and conditions of employment that casual worker has, but certainly the anticipation appears to be that everyone will be covered. Another question that we were asked was whether on-call workers would be covered. Again, I give the same answer. It will turn largely on the terms of the contract of employment. But if all the other requirements are satisfied, there is no reason why an on-call worker or a casual worker would not be eligible for the scheme. One of the most popular questions that I've certainly been asked over the last week or so is, well, what work can an employee do if they have been furloughed? And the guidance is crystal clear on this. An employee who is furloughed cannot perform any work for their employer. The scheme does not apply to employees who are going to undertake any type of work for their employer whilst on furloughing. Equally, it does not apply to employees on unpaid leave unless that employee was placed on unpaid leave after the 28th of February of 2020. nor does it apply to employees who are currently on sick leave or self-isolating. Those employees should, of course, receive statutory sick pay. Equally, individuals who in fact work for two different employers can be furloughed for each job. There is provision in the guidance that says that the reimbursement of the furloughing costs is per employer. So where an employee has more than one employer, then they can be furloughed for each job. Note also that, going back to something I said earlier about the furloughing agreement between employer and employee, it seems that there is nothing in principle to stop an employer and an employee agreeing that the employee will not take on other work during the period. We had a question in from Katie. Katie tells us that she has been furloughed and asked the question whether she can seek temporary employment elsewhere to cover the shortfall in her wage. Well, Katie, potentially the answer is yes, but I would watch and advise a little caution on this particular predicament. Remember that with your main employer, you have a duty of fidelity, whether that duty is arising by virtue of the contract or otherwise. Equally, whilst the guidance purely refers to employer, it may well be when the text of the regulations comes out that the definition of employer will be that wider definition of employer so as to encompass associated employers. This will be mainly of relevance to local authorities, where, for example, if an individual works for a particular part of a local authority and want to work for another part, that may be prevented under the regulations. In terms of reimbursement, again, we await the regulations that will deal with the reimbursement, but a process will be put in place to allow employers to make claims to HMRC. Those claims for the furloughing costs can be backdated to the 1st of March of 2020. The scheme that is proposed looks as though it's going to last until the 31st of May of 2020, but obviously depending on the development of COVID-19, it will obviously be revisited, probably on a weekly, if not daily basis by the government. A few points, if I may, in relation to statutory sick pay. Those employees who earn over £118 per week, rising of course to £120 on the 6th of April of 2020, can obviously get statutory sick pay, currently at £94.25, rising to £95.85 on the 6th of April of 2020. Those individuals entitled to SSP can now have it payable from the first day of absence rather than
We seem to have lost Alastair there. I don't know if anyone can tell me whether or not they can hear me in the chat function.
Yeah, we can hear you, Claire.
Thank you. Well, why don't I take over from Alastair in the intervening period, and if someone could WhatsApp him so he might join on again and pick it up from there. So thank you for those of you that have been including questions in the chat as we've been going along. One of the questions I'm going to pick up with Alastair in a minute, but one question that I was asked to answer that was submitted in advance was whether an employer can insist on a 20% pay cut or require an employee to take unpaid leave instead of working. And that's a very good question, and certainly one that I've been getting from friends and family, but also from clients. Ultimately, it seems to us that there's no good reason for an employer to insist on unpaid leave, given the availability of furloughing. And we would encourage all employers to act responsibly. They are ultimately what has been described as the gatekeeper for this welfare provision. So if you have somebody who has left you recently, there is no good reason not to take them back on. And please do consider doing so. There's no obligation to pay any more than the 80%. But coming back to whether or not you can change a contract, Ultimately, that's what it is. And for employees in particular, I refer you to the very helpful guidance on the ACAS website about changing a contract. And again, it comes back to those fundamentals. Does the contract allow the change? So is there an express term to allow for such a change? Is it already covered under the contract, or is there some sort of flexibility clause? If not, you will require the employee to agree to the change, or where there are employee representatives, for those representatives such as the trade union. So first of all, seek to get that consent from your employee. If there's a good reason, then you can explain what the impact is on your business. It's likely that the employee may agree, albeit in the short term. There is an expectation of consultation with the employee, and this doesn't disappear because of the current situation that we have. As Alastair has explained, there is the option to furlough employees to retain staff, but it's not applicable if you are doing any work. But do you in fact need to cut the pay? One issue that arises is if you're paying your staff 80%, those that are being furloughed, some employers are agreeing to top up to the full 80% of salary over and above the £2,500 cap. If you're then asking your one remaining employee to take a pay cut of 20%, you're essentially asking the person you've asked to stay to hold it all together to be paid the same amount as those who are now at home not having to undertake work. And you may find that that employee will go off sick, that they may not wish to work. So are there steps that you can take to look after that employee? But ultimately, if you do need it because your business is in real difficulty, then we'd suggest to employers to impose the change only for the shortest possible time, perhaps 2 months in the first instance, or as an employee, if you're being faced with this, take this reduction or leave, then you may wish to say, I consent to the reduction, but only for a 2-month period, or I don't consent to it, but I'm remaining under protest. And that will preserve some of your rights in relation to time limits. So hopefully that helps answer that one. I see that Alastair is nearly rejoining us, and while we wait for him to come back again, what I'd also say is that if changes are agreed to the contract, just to remind you again, the need to record those changes in writing within 1 month of the change, and coming into force on the 6th of April 2020 are the new employment rights, employment particulars and paid annual leave amendment regulations 2018, which set out certain further terms that need to be set out in writing and set out all in one document. So please do have regard to that and what the provisions are there. Coming back then to another question, which is about holiday. Can employees take holiday during furlough leave? At the moment, that looks like it's unclear. Obviously, if an individual is on 80%, they may wish to be able to take holiday. Certainly, there are some new provisions under the... here's Alistair's back.
Well, it just goes to show that we are in fact live and my internet connection has gone down.
So Alastair,
where did
Alastair, just to let you know what I've done, I've answered the question about contractual variations, and I was just starting to deal with the question about holiday pay, but if I can perhaps hand that over to you, which is, can employees take holiday during furlough leave? And linked to that, thank you Anne Harrod for that question, and linked to that is whether employers can force employees to take annual leave during this period.
Brilliant, Claire, thank you very much. I'm actually going to come on to annual leave, so just bear with me while I get things back up and working at this end. I was about to tell you about emergency volunteer leave. This is something that applies to employees and workers who wish to volunteer to support our essential health and social care services during the COVID-19 outbreak. In order to benefit from this, an employee has to register and obtain an emergency volunteer certificate. That will allow them to then say to their employer, I'd like to take a period of leave in order to assist health workers and social care services. There will be protection for those individuals who wish to exercise their right to such leave. An employer cannot refuse the request unless it's a small employer with less than 10 staff, but the employee can only take a total of 4 weeks emergency volunteer leave in any 16-week period. Well, many of you will be thinking that's all very well as far as employees are concerned. What about the self-employed? And hot off the press, I've received a message here from Mistress Carlotta, a self-employed dominatrix from Rawtenstall in Greater Manchester. Good afternoon, Carlotta. And Carlotta has said, well, I'm self-employed. What is there on offer for me? Well, let me give you a quick overview of the scheme. Carlotta, you can apply for a taxable grant of 80% of your average monthly profits. That's measured over the last 3 years, up to a cap of £2,500. But a condition of this is that your trading profits must be less than £50,000, or indeed your average trading profits for the previous 3 years are less than £50,000. In addition, you must have been trading in the previous tax year, and when you make your application to HMRC, be currently trading. Indeed, I think there's going to be a requirement that you'll need to show evidence that you intend to continue to trade during the current tax year and that you have lost profits as a result of COVID-19. Can I therefore turn finally to the issue of holiday, which Claire mentioned a moment ago. We do have some regulations now in place, the Working Time Coronavirus Amendment Regulations for 2020. And what these regulations permit is the carrying forward of annual leave into the next 2 holiday years. The wording of the regulation is along these lines. Where it is not reasonably practicable for the worker to use some or all of their annual leave entitlement, quote, as a result of coronavirus, including on the worker, the employer, or the wider economy or society. And in those situations, employees would be permitted to carry holiday over to the next holiday year. As far as actually taking holiday during, to go back to Claire's question, during a period of furloughing, so far looking at the guidance, I don't see any reason why this cannot be the case. However, it will give rise to questions of payment, because obviously if an individual is on holiday rather than having the status of being furloughed, it's arguable that they would be entitled to full pay rather than the 80% pay, which they would be in receipt of on furloughing. So I think we need to watch this space to see what the regulations say on that particular issue. Claire, one that's come in here, can an employer insist on the 20% pay cut?
Well, in fact, we covered that, Alastair, while you were cut off from video. So we've already done that one, but thank you very much. I think it just leaves me to sum up, which I think as we've been talking about as we've prepared for this seminar, Alastair, that the key issue here is that of common sense. Yes. And ultimately, our advice is be a responsible employer. There's 4 main reasons for that. Firstly, it's the right thing to do. Secondly, that those employees you send home, if you dismiss them or on furlough, will have a lot of time to read up on their rights on the ACAS website or through contacting excellent barristers at 5 Essex Court, and you run the risk of a claim being brought, whether it's ultimately valid or not. Thirdly, in today's world, social media and brand image is very important, and we've already seen examples in the press of those employers who've taken irresponsible decisions. But fourthly, if your business does survive at the end of this, your employees will remember how you behave. Ultimately, also, as we started with, the need here is for employers and employees to communicate. Most inquiries that Alastair and I receive are normally based on misunderstandings. Employers and employees should be flexible and should be creative. Again, as we said at the outset, there is a huge opportunity here to make business leaner, to make it more efficient, and to have better working relationships and practices that will actually encourage disabled employees, encourage those with children, and encourage everybody to be able to act in the workplace and to maintain jobs in a way that allows for a work-life balance. So there is a huge opportunity here. This is the time to trial new working practices. and to be realistic if they don't work, and to see if you can tweak them. So it just remains for me to say thank you all for tuning in. Sorry about the dropout of Alastair there, and perhaps it shows it's good having two of us on this talk. Sorry you've had more of me than you might have expected. But ultimately to remind you to tune in next week for Bobby Talale's talk on the police misconduct regime. Please also do take a look at the coronavirus guide for police forces. Given some of the headlines in the papers, it's likely to be of interest to those as citizens as well as those who practice in police law. As we were reminded at the outset, this is being recorded and this will be available to re-watch for those of you that have enjoyed it so much, or to share with your colleagues that didn't get to see it. And I understand that 5 Essex Court will soon have, if it doesn't already, its own YouTube channel where this presentation will be available. And of course, if you have any more detailed queries, or we've got to questions that we haven't managed to answer, please don't hesitate to get in touch with 5 Essex Court. Our clerks are working as efficiently and effectively as ever, albeit from home, but they can be contacted through their normal email addresses and telephones, and we thank them for their hard work, led by Mark Waller. Thank you all very much. Good afternoon.
Good afternoon.